Welcome to another episode of Husch Blackwell's False Claims Act Insights podcast. I'm your host, Jonathan Porter. The vast majority of FCA investigations involve organizations rather than individuals. Hospitals, pharmaceutical companies, universities, defense contractors, these are organizations that face significant FCA scrutiny. And yet, organizations, they don't have brains, they have people. And it's their people that lead to organizational liability. But sometimes people go rogue. If an organization has a policy that says, hey, don't do X, and they train their people to not do X, and has compliance systems that keep people from doing X, and yet some employee figures out a way to do X without getting caught, what do you do with that? That's a fact pattern that plays out a fair amount of time in FCA investigations. And I don't think it gets enough attention in our world because the FCA hammer is crazy heavy for those accused of fraud. And so today on the podcast, we're talking about organizations finding themselves liable for the false claims caused by their employees. The law on this might be surprising to you, but it's dated. I think might be in need of rethinking. And so that's our episode today, organizational liability for acts of employees. Joining me to talk about this is my law partner, Lorinda Holloway. Lorinda, listeners probably know you from past episodes, but for new listeners, Lorinda is with Husch Blackwell's Austin, Texas office. She is super sharp on all things healthcare and false claims, and while some FCA practitioners lack trial chops, one thing I'm proud of with our team here at the firm is that we've got serious trial experience, and Lorinda certainly has that. In fact, Lorinda just wrapped up a trial she won a week or two ago, and so Lorinda, congrats on yet another trial win, and thanks for coming on the podcast to tell our listeners about organizational liability for false claims.
Well, thanks for having me, Jonathan. Always a pleasure.
So, Lorinda, what we're talking about here really is what we lawyers call vicarious liability. So let's start, Lorinda, if you would, just give us a quick explanation of what vicarious liability is and why this is a thing in the law.
Sure. Vicarious liability, it really just means one person or entity is legally responsible for the acts or omissions of another person. So most typically, as you've already pointed out, it's an employer or entity being found liable for their employees' acts or potentially omissions. So it's good in the sense that, we want companies to have an incentive to train and manage their employees in order to prevent harm to others or harm to the company.
Thanks, Lorinda. And when I think about vicarious liability, I think it makes sense for like tort cases where you're trying to compensate victims. Like if a company's truck injures someone, it makes sense the company would pay for those damages because we want to make sure that the victims of torts are made whole. But it might make a little bit less sense when you get into the False Claims Act, which only applies when people or a company knowingly commit fraud. And so, Lorinda, how do courts generally think about vicarious liability when it comes to the False Claims Act?
Yeah, really a couple of different ways. I think the majority of courts will hold a company liable for all of the acts and omissions of its employees, so long as whatever the wrongful act or omission is within the scope of the employee's employment and in some way actually benefits the company. And then a minority of courts, I would say, they'll only impose vicarious liability for the acts of management level of employees, unless the company had actual knowledge of the non-managerial employees' actions. So kind of going to what you're talking about, how do you get in the head of an entity? The entity is made up of people. So most courts are going to say, look, if it's something your employees are doing, it's within the course and scope of their job and the company benefits from it. Sorry, you company are going to be responsible. And then the minority of courts are like, no, we're going to look only just to hold companies liable for management level, unless the company actually really knew what was going on.
Thanks, Lorinda. Yeah, so I think what a lot of people think about when they think about fraud is, like TV shows where you've got like a board of directors who's executing some fraud scheme. Obviously that would be enforceable under the False Claims Act, but we rarely see that. What we see more often is some lower level employee does something that is against company policy. And the question is, well, what do we do with that? And so, Lori, I think fleshing out these two approaches might make sense with a couple of examples. Let's dig into some cases. And the first one is one in my neck of the woods in the 11th Circuit called Grand Union. So, Lorinda, if you would, tell our listeners about this Grand Union case and the approach that the court took there.
So in Grand Union, it involved a large grocery store chain. Their cashiers in one of the stores were taking food stamps for ineligible items. They were accepting the food stamps. And really, the evidence showed nobody outside of that one grocery store out of this entire chain even knew that this was happening. But DOJ brought an FCA action against the whole chain, and the court ultimately imposed vicarious liability against the grocery store chain because the employees accepting the food stamps had the broad authority to decide whether to accept food stamps or not. And because, of course, the grocery store ultimately benefited from the food stamps process.
Thanks, Lorinda. Yeah, I remember when I was at DOJ and trying to talk with defense counsel about vicarious liability situations, I would talk about Grand Union. It is still good law. It's an older case. But I think this leads to a pretty harsh consequence. I mean, think about what's happening here. You've got a one-off situation where low-level employees are doing something wrong, and no one outside of that one location knows about this. And so this is a pretty drastic consequence for something that the organization, the big corporate chain itself, doesn't know anything about. And I think some courts look at this type of fact pattern and go the other way because they see the FCA as a pretty harsh consequence. So, Loretta, let's talk about an example from a case that went the other way. If you would tell our listeners about the Southern Maryland Home Health Services case.
Mm-hmm. Yeah. And just real quick, before we get to that, I mean, I hear you, but I guess the pushback on the Grand Union approach or in favor of it really would be the fact that the grocery store chain in that example, they had the ability to more tightly restrict what their employees could and couldn't do. So they had a level of decision making that they were owning. And yet to say you don't have to be responsible for it, ultimately, I think that's where the law enforcers would, where you would have been making that argument as a DOJ or U.S. attorney. But you're right. So other courts take a different approach. So in the Southern Maryland Home Health Services case is a good example. Here, a woman actually pretended to be a physical therapist when she wasn't. So she literally was fooling her employer. She was providing services as though she were a real physical therapist, and the company billed Medicare for her services by this pretend therapist. And the court rejected the Grand Union approach, the one about the grocery store we were just talking about. And this court held that when the recovery sought by the government is substantially higher than its actual losses, an employer is not vicariously liable under the FCA for wrongful acts taken by non-management level employees unless that employer actually knew what was going on. So this court took really the exact opposite, kind of giving the entity, the employer, a bit of a pass unless these decisions or acts were being done at the management level. And the only exception being, of course, if the entity really knew what was going on, that court would sort of disregard whether the person was management level or not.
Thanks, Lorinda. Yeah, it's hard to look at these two and try to make sense of this. I mean, really, this is just two courts looking at very similar fact patterns and saying in one of these, we view the FCA as a tool that is meant for pretty high-level fraud. And when the government's seeking substantially higher damages than what its actual losses were, we should just look at that with a little bit more scrutiny. And I think that's different from what the 11th Circuit did in Grand Union, where they look at what was going on and they say, well, we still want to hold this company liable for what its low-level people did. I think this is tough. So one example that we've talked about on this podcast before, my friend Troy Clark, he and I were at DOJ together. He came on the podcast a couple of years ago, and we talked about this case where this defense contractor was bribing an Army colonel in order to get defense contracts. And so in that case, Troy was wearing the criminal hat, and I was wearing the civil hat. And Troy prosecuted the colonel and the guy bribing the colonel. And then I had a False Claims Act settlement with the company. And that makes sense there because there the company was the one getting the contract. They got this big government contract that came about through bribes. And what the company said there was, look, we didn't have anything to do with the bribes. Our guy did. The guy who was running this branch made the bribes, but like our C-suite folks didn't understand it. But still, it was something where we imposed vicarious liability because of Grand Union and because, look, a company's the one that's responsible for their guy going out and bribing a colonel. But I think it's harder when you get down into lower and lower levels. And so I've got a lot of clients where they have questions about, well, I submitted this CPT code, but it was a low-level biller who chose the code, and we trained the biller not to do that. So these are really hard questions. And so, Lorinda, I think what a lot of our listeners are probably thinking right now is, well, what are we supposed to do? If our low-level employees' mistakes are going to be held against the company, what should we be doing? So, Lorinda, I'll ask you, what should companies be doing given this vicarious liability thing in the False Claims Act?
Yeah, I think it really shines a bright spotlight on what I'll call compliance hygiene. Okay. In other words, given that this vicarious liability risk is always there, this is a key reason why companies that are billing under any kind of federal program have got to have strong compliance programs and to conduct training of their employees and focusing on enforcement of your compliance policies and procedures. And of course, if you do learn of something, just considering if you learn of something that's being done, lower level employee or not, really need to take a pause, get good counsel, and consider whether you need to make a self-disclosure. But this vicarious liability, it really is, it's almost like the other side of the coin. If you could be vicariously liable, then that other side of that coin needs to be a focus on training.
Yeah, totally agree with everything you just said, Lorinda. The argument for vicarious liability is when you are having a company be liable for the acts of its employees, you're giving the company tremendous incentives to train and put in compliance measures to stop this. And so Grand Union was a long time ago. I think now grocery stores and other stores that accept food stamps, they've got processes in place to make sure that only eligible items can be reimbursed for government payment. Those compliance processes in part came about through cases like Grand Union. And so if we're thinking about this big picture, yeah, it makes a lot of sense that we're going to impose liability on companies for the acts of their employees. So in that aspect, it makes a whole lot of sense. But Lorinda, I still think there are good arguments that defense attorneys like us can and should make when we're talking about sort of isolated incidents that happen outside of the sort of scope of managerial or C-suite employees. And so, Lorinda, let's close this conversation by me asking you this question, which is, what arguments should we, defense counsel, be making on behalf of our clients when this sort of thing happens?
Yeah, absolutely. I think defense counsel have got to focus on steps that the company took to stop whatever type of wrongdoing may have occurred. I mean, the reality is, believe it or not, the government actually does not expect perfection. They are looking for robust, meaningful, not a book on the shelf, but meaningful compliance programs. And the reality is, even when you have a meaningful, robust compliance program, things are going to slip through the cracks. That's why it's a constant sweep through your processes and education and training, and then go again. That's what you want to focus on as defense counsels. Look, we may not have had perfection here. Something may have slipped through the cracks, but look at our processes that we have in place, and we're doing the best we can. And it's a constant effort to improve and to have compliant programs. So you want to also focus, of course, on how imposing FCA liability would just be an unfair result in the absence of some really improper act despite good training.
Thanks, Lorinda. All good arguments. Yeah, I think when you're talking about the drastic consequence of a False Claims Act settlement, what you want to do is make sure that you're saying, like, there are other people involved in this who could suffer through this, whether it's shareholders or vendors or contractors, other employees. And so if you've got a client where there's a robust compliance system in place and something just falls through the cracks, that's going to happen. And so demonstrating to DOJ, look, we put a lot of effort into something like this not happening. It's an isolated incident. Why this person chose to disregard their training, we will never know. But let's not hammer the organization just because someone did something they weren't supposed to do. That's the sort of arguments that we make. And so, Lorinda, I'm grateful for you coming on the podcast and fleshing this issue out, because I think this really is important. So, Lorinda, thanks for coming on the podcast.
Absolutely. My pleasure. And, having that exhibit A of this is the training that we do, man, there's nothing better. Lawyers like us love to get those real specific examples from the client. Always a pleasure, Jonathan. Thank you.
Yeah, no, thank you, Lorinda. So this is the first podcast that we're doing since DOJ put out their numbers for 2025. We're going to talk about the numbers more in future episodes, but the high level is record number of qui tams filed in 2025. And so these investigations are coming. The relators bar is responding to some of the big FCA settlements in recent years, and they're finding clients. And so the number of whistleblowers are going up, the number of key tams are going up, the number of investigations are going up. And so if you're in an industry that comes under scrutiny of the False Claims Act, now's a good time for you to re-embolden your compliance processes to make sure that you're not going to be the latest person named in a key tam and going through all of the big investigative steps that come with that. And so we're going to continue to talk about the False Claims Act here on this podcast. We hope that you'll continue to listen to us. But until next time, to our listeners, thanks for joining us, and we'll see you next time.